Hello, my name is Rory, and today I'll be discussing the legal maxim. He who ever owns the land owns everything up to the heavens and down to the center of the earth. Traditionally, this maxim implied absolute vertical ownership. If you own the plot of land, you own the airspace up to the heavens and the subsoil down to the center of the earth. In this presentation, I'm going to trace the historical development of the maxim, examine key case law with special attention applied to Ricardo, but also speak about Kelsen and Bernstein. And we'll also evaluate modern statutes and how new modern technology interacts with the ancient maxim. Ultimately, I'll argue that while the maxim survives as a conceptual starting point in modern English land law, uh, English land law has replaced absolute domain with a model of regulated stewardship heavily constrained by statutes and public policy. So, before 1066, England operated on a strictly hierarchical feudal system. The crown was regarded as owning all land. Everyone merely held estates from the crown in return for services, especially military service. Land was thought of largely in horizontal terms: who held what estate, from whom, and on what conditions. There was no developed doctrine of airspace or subsoil in the modern sense, and there was strictly no articulation of the maxim. This was the case until 1628, when Sir Edward Coke famously formulated the maxim in the Institute of the Laws of England. He used it to express the idea that landowners' rights were not confined to the surface, but extended vertically both above and below. However, Coke's phrase was more of a rhetorical shorthand than a precise technical rule. It signaled that the landowner should be protected from intrusions, whether they come from above or below, in an era before aircraft, satellites, or modern subsurface infrastructure. At this stage, the maxim aligned with a feudal vision of strong, almost absolute land ownership. This remained the case till 1925, when a major turning point came with the Law of Property Act 1925 and the closely linked Land Registration Act 1925. These reforms simplified a complex feudal estate system and modernised English land law. They shifted the focus away from broad maxims and customary ideas and towards a statutory definitions and a system of registered estates, titles, and interests. This signposted the decline of the maxim's literal force. Ownership was no longer framed simply as to the heaven to the depths of earth, but as a bundle of rights defined and limited by legislation. This takes us to the modern day, where you have the LRA 2002, which is the modern successor to the 1925 LRA Act, which completes the transition to a registration-based, statute-driven system. Land law is now dominated by statutory schemes, detailed regulatory framework, judicial tests of reasonableness and ordinary use. In this world of planes, drones, satellites, and subsoil projects, the idea that a landowner literally owns up to the heavens and down to the center of the earth is no longer workable. Instead, the maxim survives mainly as a historical conceptual reference point, not as an operative rule. Now, if we do try and apply this maxim to some modern day challenges, we can see that, especially when it comes to airspace, when Coke wrote "up to the heavens," that was a theoretical expression. There were no aircraft, drones, or satellites to compete with. Today we have all of them. Commercial airlines use high altitude airspace, drones operate at low and mid-level altitudes, and satellites orbit in outer space. If the maxim were taken literally, every overflight would be a trespass that would paralyze aviation and modern communication. So courts and parliament had to cut the landowner's claimed airspace, creating a distinction between the lower airspace, which is deemed necessary for ordinary use and enjoyment, and then upper airspace, which is treated as part of the public domain. We will see this illustrated in Bernstein v Skyview's case, and also in Kelsen v Imperial Tobacco. To the subterranean, similarly, the maxims down to the center of the Earth is incompatible with modern infrastructure. Below the surface, we now know we have oil reservoirs, telecommunication cables and fiber networks, and basic human needs such as sewage and water pipes. National infrastructure depends on having predictable statutory access to the subsoil. The maxim, by contrast, is indifferent to public interest and national energy policy. The tension sets the stage for cases like Ricardo v Star Energy and the legislation that follows, such as the Petroleum Act of 1934 and the Infrastructure Act of 2015. So the core problem is, can a historical absolute maxim in a world where land is part of a shared technological ecosystem exist? Modern law's answer, as we'll see, is effectively only in a very limited, heavily qualified form. So historically, courts applied the maxim relatively strictly, especially in relation to lower airspace. This is seen in Kelson v. Imperial Tobacco, where Imperial Tobacco erected an advertising sign which projected into the claimant Kelson's airspace from neighbouring premises. The sign did not cause physical damage to the land, it merely occupied airspace above Kelson's property. The court held in this case that it was trespassing. A landowner's rights extended to the column of airspace necessary for ordinary use and enjoyment of the land and the buildings upon it. Intruding into that space, even something as small as a sign, amounts to trespass. Moving on to Picardo, Star Energy held a license from the Crown to extract petroleum. To reach an oil reservoir, it drilled three diagonal pipes from neighbouring land, passing under Picardo's estates at depths of lower than 800 feet. Picardo had not given consent for this and sued for trespass. The Supreme Court held that Star Energy had committed trespass. Land ownership does indeed extend into the subsoil even at substantial depths, unless statutes state otherwise. The traditional maxim, therefore, at this point in 2010, is not entirely dead. However, the courts only awarded £1,000 in damages, much lower than Picardo claimed for. This is because, due to the Petroleum Act of 1934 and then the succeeding act in 1998, petroleum is vested in the Crown, not in Picardo itself. Picardo had no right to the oil. The only wrong was the technical intrusion into the subsoil. This is significant because at first Picardo appears at first glance to revive the maxim for the subsoil. Land extends downwards and unauthorized pipelines can be trespassing even at great depth. Yet the minimal damages show how weak that protection is, where a powerful statutory regime exists. The real economic value here, the petroleum, belonged to the Crown. The decision exposes a tension. The courts recognise that private rights in deep subsoil, but Parliament can effectively hollow out those rights by vesting resources in the state and limiting compensation. There are a few main statutory protections that exist in the UK. This is the Petroleum Act of 1934 and 1998, Coal Industries Act of 1994, and the Industries Act of 2015. Now, if we move on to the airspace and subterranean today. So, modern airspace, as I mentioned, recognizes two tiers of airspace. You have the lower airspace, this is the zone necessary for the ordinary use and enjoyment of the land and buildings. For example, the space into which you might build, extend, or reasonably expect privacy. Cases like Kelson, as mentioned, and also Anchor Brewhouse v Brickley House, which concerned a crane jibe swinging over neighbouring land, shows that physical intrusions into the zone are trespassing, even without damages. To upper airspace, the second part of this, above the functional zone, the airspace is treated effectively as public domain. Bernstein v Skyviews confirmed that overflights at normal height are not trespassing. This is further reinforced by the Civil Aviation Act of 1982, Section 76, which provides that lawful aircraft flying at a reasonable height do not commit trespass or nuisance merely by passing overhead. This shows that the law now balances private rights with technological and public needs. Landowners no longer have a credible claim of up to the heavens. Instead, their right stops when ordinary use ends. The public airspace begins. This position is increasingly tested by drones, which often operate in a grey area and between lower and upper airspace. Courts and regulators are still working out where exactly to draw the line, demonstrating that the maxim offers no ready-made answer for modern problems. Moving on to the subterranean rights. On the subsoil side, we see a similar pattern of qualified ownership in theory. Picardo, ownership extends into the subsoil and unauthorized underground incursions may be trespassing. But in practice, as we saw, key resources are already carved out. Oil, gas, and coal are all vested with the Crown. Deep level use below 300 metres is now permitted without the owner's consent, thanks to the Infrastructure Act of 2015. Subsoil is being increasingly used for national infrastructure. The modern framework prioritises predictability and public interest over strict private autonomy. Landowners retain enough control, but not enough to block major infrastructure projects or claim windfall profits from national resources. This leads us on to absolute ownership, which is now transferred into more of a regulated stewardship. Under the feudal system, the maxim made intuitive sense. The crown owned all the land, tenants held estates that seemed to carry comprehensive control of the plot. Vertically as well as horizontally, the idea of from the heavens to the depths of earth matched a world without aviation, deep mining regulations, or complex underground utilities. The 1925 reforms marked the beginning of the end for absolute vertical ownership. The LPA and the LRA changed that landscape. They rationalised the states and interests. They foregrounded registration and statutory formalities over broad maxims. Land began to be understood as a regulated asset, not an absolute domain. This is demonstrated in Bernstein v Skyviews, where the defendants flew over Lord Bernstein's estate to take aerial photographs, which they offered for sale. Bernstein claimed this was a trespass into his airspace, relying on the traditional maxim. The court rejected the claim. It held that the landowner's rights in airspace are limited to such heights as is necessary for the ordinary use and enjoyment of his land and structures. Above that level, the airspace is public domain. Bernstein effectively cuts the maxim in half. It preserves the rights in lower airspace but denies ownership to the heavens. The judge recognized in an age of aviation, allowing landowners to control all air above their land would be absurd. In the modern law, ownership as stewardship. Today, land ownership operates within a dense web of planning controls, environmental regulations, mineral and petroleum licensing, aviation, and infrastructure statutes. As a result, ownership is best viewed as a regulated stewardship. The landowner has significant but bounded powers. Vertical rights are limited to what is necessary for the reasonable and ordinary enjoyment, and then heavily qualified by public interest concerns. Scholars have noted that legal maxims are often oversimplified. Lord McNair suggested that the maxims can obscure analysis or be used as shortcuts instead of genuine reasoning, while Sir Frederick Pollock described them as an attempted general statement of law rather than precise rules. The maxim still plays a conceptual role. It reminds us that land has a vertical dimension and that the intrusion above and below can matter. However, as a statement of current law, it is misleading. It conceals the complexity of statutory carve-outs and the policy choices underlying modern infrastructure regimes. If taken literally, it would conflict with aviation, energy, security, and much more. So the maxim survives as a tool to illustrate how far we have travelled from feudal notions of absolute domain to today's model of regulated, policy-sensitive ownership. To conclude, the maxim wants an attractive, simple idea of vertical and land ownership. Historically, it suited a feudal system with limited technology and modest demands on the land. But through technological advancements, by 1925, the demands on the land were much higher. Case law such as Kelson, Bernstein, and Picardo all demonstrate that, with statutes such as the Civil Aviation Act, the Petroleum Acts, and the Coal Industries Act. We can see a steady erosion of any claim to absolute vertical domain. Modern English land law now protects the landowner's lower airspace and usable subsoil to ensure an ordinary use and enjoyment, but it subjects the higher airspace and deep subsoil to public interest, regulatory regimes, and national infrastructure needs. So does the maxim still matter? As a doctrine, it is no longer central to English land law. Conceptually and historically, it remains important, a vivid reminder of the move from absolute ownership to regulated stewardship. Thank you for listening.